I think we're now ready to resume. Mr. Hussain.
My Lord, thank you. 5 points on issue 1, just to finish issue 1. 1, Unuane, the critical paragraph is paragraph 83, EF 788, where the court says that the regime does not necessarily preclude the application of the bull-teeth criteria. I would underscore necessarily and underscore bull-teeth criteria. The bull-teeth criteria are the analog of Maslov 71. They are weight neutral. We would respectfully submit that that would not be the position. Unuane would not have said that if Unuane was a Maslov case, still less if it was a Maslov 75 case. Unuane was an adult case, a non-Maslov case. First point. Second point, to finish Appellant, you'll be very relieved, I'm not going to take you to it.
Well, perhaps we should just note paragraph 84 of Unuane as well, that the difficulty identified was the fact that the tribunal had simply gone through the immigration rules exercise without carrying out its own assessment.
My Lord, absolutely, sorry, you're right, yes. You're absolutely right. You're absolutely right. And that's the problem with fitting everything, with looking at everything through the rules. Still more if what you're applying isn't weight neutral. Maslov 75 is not weight neutral. Second point, my Lord, yes.
I'm sorry to take up time on this, Mr. Hussain. Which version of the rules and legislation was Unuane addressing? Because here we've got section 117 capital C.
Everything.
2012 which seems to track the current version of the rules, including the very compelling circumstances test at subparagraph 6.
It looked at everything. It looked at 2012 and 2014.
Including the legislation.
Yes, yes.
All right, that's sufficient. Thank you.
Not all. Second point, my lords. Appellant, you'll be relieved. I'm not going to take you to it. I just want, can I please ask you to read 49, paragraphs 49 to 50, EF 506. And that shows, in my submission, that not only is Sir Stanley rejecting the condition precedent approach, but he's also relegating the correct approach, which is a general approach, a general test, to the facts of the case. The key paragraphs, 49 to 50, page 506. The third point I wanted to make, please. Can I do by reference to my bullet point? And this is the other way in which the tribunal erred. 10B. 10B, it didn't consider the Maslov factors, at the very minimum, I'm entitled to say, even allowing the very compelling circumstances rubric, it didn't consider the Maslov factors at all. We address this in paragraph 96 of our written case at EF 84 to 85. Fourth point is paragraph 8B of my note, my bullet point, which is that if the regime represents a considered policy as regards Maslov 75 cases, then the limits of the margin are exceeded. Your Lordship, the President, referred both in Aguiarco and Ali to the limits of the margin. They are exceeded if the regime represents a considered policy for those cases. and it's exceeded because it's not in conformity with the convention standards. That's the test in the case law. And Sir Declan will recall the Gillam case, which we cite, where Lady Hale said, you can't defer if there isn't a considered view. That was the case about whistleblower protection to judges. Police had been excluded. Parliament had thought about that. Nobody had given any thought to exclusion of judges. There's nothing to which this court could defer. And that's EF 1426, Gillam, the Gillam case. And the last point on issue 1 is a point at C that irrespective, I accept I need leave on this, and in our pleading note we've tried to explain why we should get it. It's a very important point. There's no logic for the read across in the scheme to medium offenders of the same safety net as is applicable to serious offenders. You've got the sliding scale principle, and we suggest that a very compelling circumstances safety net could be read across, but not with the over and above addition. NA Pakistan was the case which read in the safety net to medium offenders. EF 526, paragraphs 25 to 27. With respect, NA was correct, Lord Justice Jackson was correct to say you've got to have a safety net. But with respect, he was wrong to read across the same safety net as for serious offenders. That simply doesn't make any sense. Not logical. And we address this in our printed case, paragraphs 84 to 85. Issue 2, I apologise for the fact that I'm going to invite you, my lords, I'm afraid, to take it from the papers.
Yeah.
It's fairly straightforward. I respectfully submit it's not of the same order of difficulty. I ought to have addressed you. I apologise for not doing so. But there are 2 points we make. First tier tribunal didn't make any material error. Second point, upper tribunal applied an overly reductive and narrow approach to very significant obstacles to integration. We respectfully submit that my Lord Sales was right in the Kamara case to say what he said about integration. And it is a legal concept, not enough for the tribunal simply to address the statutory words if it gets the legal standard wrong. Those are my submissions.
Thank you very much, Mr. Hussain. Eventually, Sir James, we come to you.
Well, thank you. My learned friend's about to have the shortest reply known to man. I calculated it as 1 minute in length. I'm going to start with the legal structure that applied in this case. I hope you'll forgive me for going back to that. The relevant statutory and immigration rule provisions were those in the 2002 Act, but as amended from July 2014. And the version of the immigration rules that is relevant is the one that was current from the 28th of July 2014. So far as the legislative scheme is concerned, it may be as well to have it up on your screens at 428. And I wanted to make 6 points in relation to that statutory scheme. First of all, Parliament has set out provisions relating to the weight to be attached to the competing considerations under Article 8.2. That's what's referred to in the primary legislation 117 capital A subs 2 and 3 as the public interest question. And it has done so, we invite you specifically to note, in a way in which the legislative scheme in the primary, unlike the immigration rules which govern by way of policy the executive's action, this part, says 117A1, applies where a court or tribunal is required to determine whether there's a breach of Article 8.2. So it's specifically a direction to courts and tribunals of the equivalent balancing that applies to the executive under the immigration rules as a matter of policy. But 117A1 is of some importance, perhaps.
Is it fair to say, Sir James, that one can infer from 117A2, where it says the court must in particular have regard to the considerations listed in 117B and C, that those considerations are not exhaustive?
My lord, it is.
Thank you.
Secondly, Parliament has specifically addressed that matter in the context of the deportation of foreign criminals. See in particular 117C, capital C. That has for some time now been a matter of evident and real public concern. And the basic justification and public interest were established and noted by Lord Reid in the Alley case at paragraph 14, page 556, if you can slip quickly to 556. By reference to the documents that my lord then cited. That was by reference to the 2007 Act, but the same points about the public interest apply. The level of concern and justification for it, as you say, are apparent from the documents forming the background to the 2007 Act. Of course, at that time, that is at the time of Alley, unless my lord's wry smile is going to lead to a question.
My wry smile is that I've made an observation in parentheses there about the effect to which delay affected the system. I might reflect that, to judge from this case, nothing's changed.
Yeah, well, my lord, mercifully, we're not facing a challenge on that ground. It seems to me every other ground, but not that. But at that time, of course, at the time of Alley, there was no need to consider the later rules or the later legislative amendments introduced in 2014. As you noted in the final sentence of paragraph 2 at 553. But you did have the old version of the rules, and you can tell it's the old version if you go to 399A, and it refers to no ties. But you did make some comments of significance about the significance even of those rules directed at as they were as a matter of policy to executive action, rather than the focus of the primary legislations we've now seen it to be at courts and tribunals. So the points you make about the rules apply a fortiori and with a broader and more specific purpose to tribunals and courts. But all the points you make about constitutional legitimacy and so on in relation to the rules apply, we submit, a fortiori. I'm not going to go through them. You'll be very familiar with them. The other members of the court will also, I'm sure, have read the Alley judgment. The key paragraphs for that purpose, it might be thought, are paragraphs, some of which are specifically directed at the rules and therefore of lesser importance in our case, but a fortiori nonetheless, are paragraphs 17, 21, just cast a very quick eye as we go. 38 if I'm not going too quickly. Particularly the passage between F and G on page 565. But 46 as the final paragraph in that sequence, a paragraph of some importance as well. That democratic legitimacy in relation to the rules, as I say, applies a fortiori to the primary, but the points were picked up and run with by the Court of Appeal in the NA case on democratic legitimacy and the importance of that. At paragraphs 11 and 12 on page 522, a court which includes, I think, Lord Sales and Lord Justice Jackson and Lady Justice Eugene Sharp. But I would just invite you to cast an eye down 11 and 12. The third point is that it's to be noted that there has now been parliamentary intervention at the primary legislative level in two ways. First of all, in relation to the 2007 Act, the relevant provisions of which, if you want them conveniently set out, are at 517 and 518 of the case you're looking at. Pages 517 and 518, in other words, the 2007 Borders Act, including making provision for automatic deportation. Again, those provisions I'm sure will be familiar to you in section 32. And note even at this stage that excluded from automatic deportation are people who were under 18 at the date of conviction. Look at section 33 sub 3 at the top of page 518. But you now in addition have the changes made into the primary legislation in 2014, the scheme that we are looking at. Check one further reference, if I may. Yes, just on the structure which that has led to. Now we've got the two levels of intervention, and now we've got the rules which do their thing with the executive, and the primary legislation in 2014, which introduced the framework directed at courts and tribunals. The position that, as it's ended up, was conveniently summarised by Lord Justice Leggett in the Court of Appeal in CI Nigeria. You just go for that purpose to page 640 in the electronic bundles, please, at paragraph 20. Which we respectfully submit is an accurate summation of the law as it currently stands. including in effect the idea that sometimes, no doubt as a matter of habit, tribunals will refer to the immigration rules, but given that they are directly replicated in the primary and the primary is directly directed at courts and tribunals, in truth, the code is now contained in the primary legislation whenever it gets to the tribunal system. That's the third point. The fourth one, if we go back to the primary legislation in 117C, at page 429 in the electronic, the two basic principles are that the deportation of foreign criminals is in the public interest, and the more serious the offence, the greater is the public interest in deportation. That's specifically set out in 117C 1 and 2. And those are, as the Court of Appeal put it in NA at paragraph 22, page 525, we don't need to turn it up, as they put it, particularly strong statements of public policy, and courts are obliged to respect the high level of importance which the legislature attaches to the deportation of foreign criminals. But that is essentially tracking, in relation to the new primary legislative regime, the comments made by Lord Reid in Ali in relation to the immigration. And you will note that serious offending is a defined term, in effect, because if you go to 117D on page 430, you'll see that foreign criminal is defined by reference to, in particular, by reference to the 12-month sentence. There are other categories in Roman 2 and Roman 3, but it's 12 months for present purposes. And then you know the structure that then follows, which I'll come to in a second. But just to note at this stage, therefore, that the seriousness of the offending, very serious reasons, if there is an equation between those two, which there is built into the scheme. That's why it draws the distinctions it does. It defines what amounts to serious at base. It draws distinctions between the rules that apply if you're between 1 and 4 years, and then if you're over 4 years. So the seriousness of the offending, the very serious reasons, if you want to use the Maslow language, is built in to the scheme. And that leads to the fifth point, which is that the legislative scheme also addresses, if you want to look at it in balancing terms, the other side of the scales. And it does so in 117C 3 through to 6. In the context of the less than 4 years cohort, the approach is that the public interest requires deportation unless one of the two exceptions applies. And the relevant one here is the one with the 3 cumulative conditions set out in 117C 4. And of course, again, as was pointed out, I think, by the Court of Appeal in NA, if you're within those exceptions, that's it, as it were. The Article 8 case is made in your favour. But it is no accident that those conditions reflect precisely the sorts of concerns identified by the European Court of Human Rights in Maslow. Are you socially and culturally integrated? Have you been resident here for most of your life? And so on. Those are the substantive Maslow criteria that we're focused on, and they are also, therefore, baked into the statutory scheme. There is then, despite the slightly curious drafting of 1173, there is then an additional set of questions, sometimes described as the safety net questions, in 117C6. I say slightly oddly drafted language because, as the Court of Appeal in NA at paragraphs 25 and 26 decided, you just flick to that at 526 in the electronic, they in effect decided that there had been an Inco-Europe type error in the drafting of the legislation, which they corrected. And the result is, to cut a long story short, that 117C6 applies to the 1 to 4 year sentence category. So you ask, in addition, even if you don't fall within exception 1 with its 3 cumulative conditions, you still go on to ask, are there very compelling circumstances? So the analysis, which is what the upper tribunal did, involves a consideration of whether exception 1 applies, with all the relevant Maslow criteria baked into it. B, even if it doesn't, are there very compelling circumstances over and above those in exception 1, outweighing the public interest in deportation, which is given significant weight for those with a particular sentencing bound by the earlier provisions in the section. And ultimately, what that analysis, statutorily required analysis, requires you to do is to strike the Article 8 balance. My Lord Stevens. Yes.
Yeah, I was just checking to make sure that I understood it correctly. All the Maslow factors are taken into account then under 117C6, is that right?
It's a combination of 117C4. Look at the cumulative conditions in that, and 6.
Yeah. But every single one of the factors in Maslow have to be taken into account, no matter at what stage it is, either under 4 or 6.
The substantive criteria, yes. And the debate which we'll come to is whether or not it sets a test which is triggered just simply because you happen to be someone who's lived here for a long time. But all of the substantive criteria on which there was focus in Maslow are within the scheme. So are you a child? How long have you lived here? All of that. It's baked into the scheme. That's the submission.
And those have to be considered by the decision maker directly. That is, for instance, as to whether the offence is a serious offence and the nature of the offence, or the nature. Your argument, as I understand it, includes that the sentence that is imposed takes into account the youth of the offender. But at this stage, at 117C6, there would be express reference to a juvenile offender. Is that right?
Yes. Yeah.
Yeah. And also,
exactly.
There would be express reference to the desire to reintegrate, the duty to reintegrate a juvenile offender into society.
My Lord, that's taken into account already, I respectfully submit. And I'll come to reintegration in due course, but you'll remember in Maslow, the duty of reintegration did not lead to some absolute preclusion.
Oh no, it doesn't.
But I earlier asked the question, how can you be reintegrating if you ship them off somewhere else?
No, it obviously doesn't, it's not a trump card by any stretch of the imagination.
It led to the seriousness of the reasons.
Yeah.
And but that can be taken into account.
But it has to be taken into account that by deporting, you are not reintegrating into that particular society. And that is a factor to be taken into account.
Well, my Lord, I'm not sure that it would be an error of law not to refer to the words in the judgment. You are considering whether or not to deport them. That's what you're doing as the decision maker and the court. So it won't be lost on you that if you decide that the balance is in favour of that, then out they go.
Yeah.
That is built into both the sentencing and to this structure without the need specifically and expressly to refer to that.
Yeah, so long as it's either implicitly or expressly referred to.
So long as it's well, it's built in, I respectfully submit.
Okay.
That's how I put it.
Thank you very much.
Sorry, Mr. Eady.
My Lord, the Lord Chief Justice, yes.
Yes. I just wanted to be clear. It's clear that in 117C6 there is a balancing exercise going on where you have to balance the very compelling reasons, circumstances with the other factors that may be put forward. But am I right in thinking that under 117C4C there is no balance, in the sense that it is 4A is a hard-edged matter of fact. It is completely irrelevant what the seriousness of the offence is. 4B certainly doesn't seem to be related in any way to the seriousness of the offence. Can I take it that the question of integration is one which doesn't take into account the seriousness of the offence per se, because all one is looking for is to see if it presents an obstacle, and if it does present an obstacle, then one looks to the Maslow principle to see the size of the obstacle. Is that the way in which it happens?
My lord, I think that's probably fair. I mean, I've slightly viewed it as being that the legislation taking all of these provisions together sets out a strong weight for the public interest in deportation if you're convicted of a certain type of offence. It then says, are you within exception 1, which does, I suspect you're right, ask for binary answers to binary questions. And then there is the overall balance that is thrown back at you at 117C6.
Yeah, but you don't go to 117C6 if you've managed to escape under 117C4C.
No, out you go.
And there, of course, well, if you succeed in that, if you succeed in showing very significant obstacles, and you bring can you bring Maslow in at that stage with a view to demonstrating that because of your youth, your character, background, etc., that the obstacles are significant? Are you entitled to do that?
My lord, you're entitled to bring in anything you want that would be a significant obstacle. So if you were relying upon youth, that would not be irrelevant to see. But I think you're still also right that requires a binary answer. And if you bring yourself within exception 1, then when I said out you go, I mean out you go from the system, because your Article 8 right to stay has been established.
And can I take it that the upper tribunal therefore had to address 117C4C on that basis?
They had to consider the age of the person and all the things that were put forward on his behalf as amounting to very significant obstacles. I don't think it was his youth was a specific point in his favour at that stage.
Yeah, but I just want to be clear that one needs to take into account what Maslow says about reintegration at that stage. That's the point I'm trying to get to, or not. I mean, that is in a sense a binary question as well, Mr. Eady.
Well, my lord, I'm not sure about that. I mean, I think you would be able to say if there are specific difficulties because I don't know, I'm in the middle of a course which is designed to keep me on the straight and narrow and deal with mental health issues I might have or whatever it may be. I mean, the reason I'm hesitating about giving you the binary answer is because I can see a series of facts where the thing would or wouldn't be relevant. But ultimately, it's up to you as the applicant to make whatever case you wish about the obstacles. They could relate to integration in that sense. Does that make sense? I hope that's not too opaque an answer.
Of course. Thank you very much, Mr. Eady.
I'm grateful. My lords, I wanted to finish as a sixth point. I think it was a point that my Lord Reid was interested about Uduani and how that plays in.
Just before we leave the statute, I'm just trying to work out how it works. If you have applied 117C4 and you've decided that neither exception 1 nor exception 2 applies, and that there aren't very compelling circumstances, then you're compelled, I think, to conclude that the public interest requires deportation.
That is the Inco Europe point.
Now, when one goes back to 117A, the exercise, the consideration under 117C is something that's obligatory, but it's not exhaustive of the what's called the public interest question. But it must in particular have regard. What I'm wondering is, if the if the 117C exercise did not adequately reflect what was required by Human Rights Act, then I suppose you would have to make good that deficiency under 117A.
I think in theory that is right, but the courts have all proceeded and the tribunals have proceeded correctly in my submission on the basis that this should be broad enough to allow you to take into account everything within the confines of 117C. And I don't want it to be too opaque, what I meant by the Inco-Europe question.
Yeah.
Because when you first read it, I think my Lord read it a bit as I did when I first read it, which is to say, on the natural meaning on one view of it, the moment you aren't within exception 1, the public interest requires, and that's the end of the story. The Court of Appeal corrected that and put that right, so that you then have, in addition, even in the 1 to 4 year bracket, you still have to go to 117C6. It's that, as it were, balloons out to reduce the need for the in particular part of 117A to operate.
Yeah. 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 In a sense, paragraph 75 of Maslow isn't saying anything very remarkable. I mean, it seems pretty obvious that if someone spent virtually their entire life in one country and then it requires very serious reasons to send them to another jurisdiction where they may have no real, well, they obviously haven't got any life. And the question really is just how does one take that into account within the scheme laid out in the statute?
Well, the answer to that is you start with exception 1 and you look at exception 1 subpara A.
Yeah. And
no one is saying that it's irrelevant that you happen to have been a child for most of that period.
Yeah.
It all feeds in. Can I just, I've made the point about Inco. Stevens had a question, and then I was going to go to Uduani again.
Yeah,
I do.
End of story, isn't it?
Yeah.
Right.
I do apologise in the sense of if you do carry out a balancing exercise under 117C6, and the balance comes down in favour of family life as opposed to deportation, but only just on the balance, would that be a compelling reason? There would be a breach of the Human Rights Act if you did deport, because the balance comes down in favour of not deporting. But it wouldn't be a terribly compelling balance.
Well, that's true. I mean, I'm slightly worried that feels a bit like a belt and braces point. I mean, the idea of very compelling circumstances is designed to ensure that the weighting that Parliament considers it to be appropriate is applied within the analytical framework which it's set out. So, of course, you're right, but it's question begging.
Yeah.
I mean, it's designed to make sure that you don't breach Article 8, but this structure, this legislative structure, is all designed to give effect to the margin which has been acknowledged that states have in this sphere, and that Lord Reid talked about in Ali some length. This is the result. You are allowed to weight the analyticals in this way. If you start, I mean, obviously it could be challenged as incompatible, but there's no suggestion of that here. Despite some of the arguments that were mounted this morning, there's still no challenge to that here. But you are entitled as a democratic state to weight the public interest in this way. That's what this is doing. It isn't designed to try and get to a place where you breach Article 8 or you don't at the end of it. It's designed to cover Article 8, but to do so in a way that requires you to go through these sometimes more difficult hurdles for an applicant if you've entered the door of the analysis through having committed what might be characterised as a very serious offence in the first place. That's how we put it. But my lords, I wanted to get on, if I may. Uduani, which I know my Lord Reid was interested in. Could you go back to 787? And the reason for going back there is because I wanted to show you and just invite you to read what is said between the bits that I think were cited either side of this. I think Lord Reid cited paragraph 84, which starts the applicant's deportation, which is about the facts of the case. And I wanted to show you the bit from 78, dealing with the immigration rules, not the primary, but there it is, dealing with the immigration rules. Can I invite you to read from 78 through to the end of 83? And I think the paragraphs will make the point that I wanted to make or draw your attention obvious. So the Strasbourg jurisprudence can run, and you'll see that as in the immigration rules, so in the primary we submit. There's nothing wrong with having this structure. It doesn't preclude you from taking into account the bully teeth criteria, doesn't prevent you from doing the weighing, doesn't prevent you from taking into account Strasbourg jurisprudence as part of that analysis. It is just a framework, but importantly, and this is the democratic mandate, with the weighting that Parliament has decided is appropriate in a context such as this, once you enter the door through serious offence. Can I then turn to the facts very briefly? And I start, unsurprisingly, with the offending. Just to remind you, 2010, 3 counts of attempted robbery as part of a gang attempting to rob people at Mortlake Station, 12-month referral order. So that order builds in juvenile offender, obviously. 2011, possession of an offensive weapon, which was a knuckle duster, referral order again. So 15, I think, at the time of that offence, 14 at the time of the first 3 attempted robbery ones. 2013, age 17, 3 attempted robbery and handling stolen goods, 3 years imprisonment, reduced from what would have been 5.5 years for a 17-year-old not of good character, as he wasn't, reduced on account of the guilty plea, the mitigation, and taking into account age. So age already taken into account there as well. And if you go to 181 in the bundle, you should get to the FTT decision. And I go there as a convenient source for the sentencing remarks of the trial court for the 3 years offences. And 181 in paragraph 4 of the upper tribunal's judgment. Can I just invite you to cast an eye down at those sentencing remarks? Perhaps sufficient to read just to the end of the 5th line on the 2nd page, 182. So as you can see, and it's evident that these matters would be regarded as key by the European Court of Human Rights in Strasbourg if the case law is anything to go by. Repetitive offending, not a one-off, but an escalating pattern of similar offending over a 3 to 4 year period. And if you go from there to the Court of Appeal's judgment, if you would, at paragraph 8, EF 141, you will see the pre-sentencing report description in the quote within paragraph 8. The index offence, I'm reading after the ... dots within the quote on page 141. The index offence is assessed as part of an emerging pattern of offending relative to acquisitive crime, threat of violence and weapons. It also represents an increase in the seriousness of AS's offending. So repetitive offending of that kind. But secondly, the nature of the offending is both serious and violent, and indeed, as we've just seen, increasingly serious and violent. And that offending led to the sentence for the offences that were committed whilst on the cusp of adulthood. This isn't some youthful indiscretion anymore. This is a 17-year-old applying calculated and a predatory approach, it appears from the sentencing remarks, targeting the young and the vulnerable at night. And you saw from the Court of Appeal judgment that the likelihood of offending in that passage I've just shown you was medium. And as the upper tribunal judgment noted, sorry to jump around between judgments, we'll come to the upper tribunal judgment in due course, but just for your note, as the upper tribunal judgment noted at paragraphs 49 and 50, that assessment of the likelihood of reoffending hadn't reduced as the result of treatment. And we note also that there has been a subsequent conviction for assault by beating whilst in custody in June 2017, for which he was sentenced to 4 weeks imprisonment, suspended for 12 months. But that is referred to in AS's anonymity application bundle, page 52, and there's a click link in the penultimate footnote or reference on that page.
I'm sorry, Sir James, just one question, if you wouldn't mind.
Yeah.
The sentence reduction from 5.5 to 3 years was on the basis primarily of the plea, wasn't that right?
I think that's right from the sentencing remarks primarily. It's not.
Yeah. So you can't compare. That wasn't because of his age, because the starting point that was used was a starting point appropriate for a 17-year-old. So his age, I don't think, made any difference, given the starting point used. Now, it may be that the starting point for a person of full age is rather different, and that might be a relevant consideration. But I don't think the plea would have made any would have had an age factor to it, so far as I can see.
I think you're right. The plea was obviously critical, but I think the age comes in, if at all, and I think it does, through the mitigation and the report and his letter.
Well, the age is probably actually through the starting point, because the starting point is for a 17-year-old.
My lord, you might be right, but you'll see from the sentences that follow the reference to 5.5 years in the penultimate paragraph of the sentencing remarks that there were other things that played into the reduction.
Yeah. Okay.
But you're right. I think it was principally driven by the starting point would have taken in age, and then principally driven by the guilty plea.
Yeah.
I was going to turn to the findings and approach of the upper.
It's 225.
Findings and approach of the upper tribunal, if I may. And we note at the outset that the upper tribunal concluded in a separate decision annexed to their judgment that the FTT had made a material error of law. In particular, they hadn't cited or worked through the primary legislation at all, even though that was the applicable legislation, or the new version of the rules. But they then went on to consider whether that error was material, and they concluded in that error of law determination that it was, for the reasons that they gave. In particular, some of the relevant factors had been left out of account and not considered. And so the consequence of that was that the upper tribunal reconsidered the case on its merits, and in effect became the primary fact finder. We've dealt with it in some detail on our case. That's the upper tribunal decision at paragraphs 15 to 23. As you've seen, they took over from the FTT some of the findings with immaterial alteration. See paras 3 to 4 of the upper tribunal judgment on page 161. But they consciously did not incorporate the judge's finding, the FTT judge's finding of about very significant obstacles to integration. That was analysed and specifically not accepted by the upper tribunal. So they come to the matter, as it were, afresh, redetermining the appeal on the basis of all the evidence before them. And first of all, in relation to whether there were very significant obstacles to integration, you'll remember that's the third of the tests outlined in exception 1. They found that the first two were met. A and B of sub 4 were met. So the debate raged around very significant obstacles. And so far as that is concerned, that's dealt with at paragraphs 31 and following, or 30 to 46 in their judgment. 30 is on page 168. They accepted that there were some obstacles to integration in Iran, and they identified them and thought about them, 31 and 32. But they held that they were not significant or very significant, set in the context of all the relevant considerations, so as to preclude the re-establishment of a private life in the country of nationality and origin. They then analysed the other features going to the nature and extent of those obstacles, including in particular, just to spin through them, he speaks Farsi, para 34, he's an intelligent person who's academically capable, para 34, he's completed catering and cycle repair courses and interested in becoming a mechanic, 34. He's assertive and has a robust side to his character, as indicated by the offending. If there was an understatement, there it is, 43. On the evidence, they concluded that he would be able to adapt to life in Iran because of his intelligence and ability to speak the language. That's a specific finding of fact at 35. He isn't and wasn't utterly isolated from Iranian culture for the reasons given at 36. They took it as relevant that the mother had continued to visit Iran, retains connections with the country and has a close friend there who would be likely to afford him some assistance in terms of integration. And it was important that he had at least one friendly point of contact there. Unrealistic, as they found at 38, to suppose that she would provide no assistance or support, bearing in mind the close friendship with the mother. And then they took into account specifically and carefully the medical evidence adduced on his behalf about the traumatic memories from childhood and domestic violence and all of that, for which he'd received some treatment, 39 to 41, and concluded in the end, 44 and 46, that there would not be very significant obstacles to integration in Iran, and therefore he did not fall within exception 1. And for good measure didn't fall within 399A of the immigration rules in identical terms. And so on that basis, they went on to consider whether there were other very compelling circumstances over and above exception 1, which might sway the balance against deportation, and they concluded not. That's the analysis in 47 to 51. There's been some debate around how they approached the matter, and in particular with focus on 47, without getting too far ahead of myself as I'm here. can I make these points about paragraph 47? Firstly, you only get there, and they, that is the upper tribunal, only got there, having worked through the legislative scheme and having thus assessed that there was serious offending of the kind defined in the statute, that he fell within the 1 to 4 year bracket. They had also applied and worked through the exception 1 criteria, including, as I indicated earlier, building in the key elements of Maslow as they went. How long had he been here? They fully took into account that he'd been here since he was 9. They considered whether there were very significant obstacles. They considered all the submissions that he had made about that, which don't appear to have included, if you're interested in reintegration, any particular submission about reintegration. And then, and only then, did they get to very compelling circumstances, and they examined whether they existed. They cited paragraph 75 of Maslow, so they were well aware of that. They did not say that the Maslow considerations were irrelevant or unimportant. They rejected the idea that 75 established some sort of, as they put it, threshold to be met in every case where he offends as a juvenile. So they weren't excluding the fact that he was a child or the length that he'd been here as relevant and important to the analysis as factors. They simply rejected that it wasn't a test which operates to trump all other factors, or indeed the weighting within the statutory regime. And they were correct to do so. I'll come back to that when addressing the Maslow point directly. But in any event, they then specifically considered age in the final sentence of 47 when he committed the offence, that he was a juvenile at that stage, if only just. And then they came back to it in doing the balancing at 49. And look at the wording of the penultimate sentence of paragraph 49 with Maslow in mind. The offences for which the appellant was convicted were plainly very serious. So they go through all of the exercise, they take age fully into account, they weigh it, and then they reach that conclusion about the offending, a conclusion entirely open to them, having taken you through the nature of the offending. And indeed, it may be worth standing back and just asking the question, well, without the Maslow analysis and emphasis on a settled migrant or minor when offended, it would have been a very different approach, since a 3-year sentence for robbery with no significant family tie, little actual private life disrupted in the UK, it would have been a very simple answer on proportionality. So it must be that he was and exhibited the features of the Maslow settled migrant, if you like that phrase, and was a minor when he offended, that led to the very careful consideration that they gave to all of the factors under the statutory scheme. So back to the factors that bore on the very compelling circumstances, the upper tribunal, as you see from those paragraphs, took into account the appellant's age when he committed the offence, although it is to be noted that unlike other cases where there are effects on children at the point of deportation, we have none of that concern here. He was and is an adult now. So the juvenile element here relates to how long he has been here and the exception 1 analysis, but also relates to the fact that he was 17 when he committed the last and most serious group of offences in the escalating pattern. They also took into account at 48, as you see, the strength of the bond with his mother and the effect on her. The fact that he was a victim of and had witnessed domestic violence was taken into account at 48. But then so ultimately in the balancing exercise was the, quote, very serious nature of the offending. So that's the analysis of the upper tribunal. So far as the Court of Appeal is concerned, only 2 grounds of appeal were run. There was no challenge to the legislation. There was no challenge to the structure of the rules. There was no incompatibility because there was a design flaw in the legislative scheme. That was simply not a ground of appeal at all. In essence, what was being challenged under the two grounds was, one, a challenge to the error of law decision appended to the upper tribunal's determination. It was said that there was no basis for the upper tribunal to have interfered with the FTT. And secondly, the upper tribunal's approach to the redetermination of the appeal, with their redetermination flawed in the ways you see dealt with in the Court of Appeal's judgment, and only in those narrow ways. And the Court of Appeal concluded as to the first that they should apply the principled approach laid down by Lord Sales in A.J. Angola to cases in which error of law might be said to be immaterial. And they concluded that the upper tribunal had reached a perfectly proper decision, that it was on no view immaterial. Not merely were they entitled to reach that finding, said the Court of Appeal at paragraph 53, but they were, quote, plainly right to decide that the FTT had not applied the correct approach. That is, said the Court of Appeal, in both form and substance, for the reasons expanded on in the Court of Appeal's judgment at 54 to 55. And as to the second, see paragraphs 56 to 61 of the Court of Appeal's judgment, they concluded the upper tribunal had applied the correct approach in principle. They had adopted the broad evaluation approach that, again, Lord Sales, when it was Lord Justice Sales, set out in the Camara case. And they had correctly considered the issue of very significant obstacles. There had been no error, and they'd been entitled to reach the conclusions that they did. It's also to be noted that they did consider Maslow as part of an overarching submission without much of a punchline attached to it, it appears at that point. They did so at paragraphs 50 to 51 of their judgment, and they did so by reference to the correctness of both the Court of Appeal in Appellant and their understanding of Lord Reed's judgment in Alley. Can I then turn to the Maslow ground and the key principles and approach? And again, if it's not too inhumane, 6 submissions, if I may, in relation to the Maslow ground. But firstly, Parliament has reinforced the weighting of the public interests involved in primary legislation. That is a matter that is to be accorded very significant respect by the courts, as was noted by Lord Reed in Alley and the passages that I've taken you to. There is a strong public interest in the deportation of criminals, and Parliament is entitled, within the margin that is available to them, to set not merely the weighting of that public interest side of the scales, but also to set the weighting of the analysis overall. That is what has been done in the primary legislation. That's the difference with, and it's a difference, not a distinction, because it's a fortiori. That's the difference with Alley. But they're entitled to do that as a reflection of the margin which is open to them and which was the subject of comment in both the Supreme Court in Alley and in the Court of Appeal in NA. But secondly, the approach under the Strasbourg jurisdiction.
I'm sorry to interrupt you, but
Hold on, I'm so sorry.
But wasn't what was regarded as critical in Unuani the fact that the courts and tribunals had an independent role to play in carrying out their own assessment of proportionality, doing the balancing exercise? And the trouble with trying to do it in legislation is that it can't. Well, there may be a problem about doing it by legislation.
It can influence, but it can't exclude. And my lord, that is my submission about what the primary legislation does. There is plenty of scope for independent assessment a la Udouani in applying the various stages of the analysis and in according proper respect to the weighting of various factors, both overt and within the structure of the analysis that framework sets out. None of that is to exclude the role of the court. Indeed, on one view, when you get to 117C6, as the Lord Chief Justice pointed out, there is a balancing exercise at the very end of the process anyway, unless you've escaped out of the side door because you're within exception 1. So the two, I respectfully submit, are not inconsistent. And I apologise if I've been giving the impression that I was overstating it. It is the framework that Parliament has set, but it doesn't in any shape or form exclude the ability of the court to make independent assessments within that framework, including, as I say, ultimately under sub 6.
And at sub 6, presumably you're entitled to take account of all considerations. And I say that because you, as in the present case, the person might, for example, meet some of the criteria for exception 1, but not all of them.
Yes.
And
you're entitled to build those back in.
Yes, exactly. They don't just drop out of the picture.
No. And I think there's been case law exactly to that effect. It might even have been NA, but I think that the NA makes precisely that point.
Yeah.
So back in they come. You don't, as it were. I mean, our case would be a pretty good example. Yes, no. Yes doesn't drop out necessarily. But of course, ultimately, tribunals are trying to react to the facts and arguments that are presented on behalf of the applicant.
Yeah.
The second submission I was going to make under Maslow was that the approach under the European Convention on Human Rights is factorial. The Bultiff criteria were described in Ali at paragraph 26. If you go to page 561 in the electronics, it might be worth just a read of that. It's quite a long paragraph, but it encapsulates the approach that you'll be very familiar with, Bultiff, Una, and then Maslow itself. And as my lord put it in relation to Maslow, just above the letter F, for instance, when assessing the nature and seriousness of the offences, it has to be taken into account whether the person committed them as a juvenile or as an adult. As a factor to be taken into account. And note also the analysis of the development of the Strasbourg case law by reference, for example, to Jeunesse at paragraph 29, perhaps on page 562. Again, unsurprisingly, with the interest of children being fed into the analysis. There, of course, perhaps significantly, there, of course, you were dealing with the impact on children of the grown-up parent being deported. That isn't, of course, our situation. Our situation involves the juvenile elements principally at the stage of offending, even though only just, with the person now being an adult when he's deported. And the first consequence of the analysis being essentially factorial in that way is that it allows for the various factors to take account of the individual facts of the particular case in question and to be placed in either side of the public interest balance. So, for example, you can take into account that a person was of a particular age when they committed the offences, but there may well be differences, and potentially of a significant kind, between different offences and between different ages when you offend. And on particular facts, some factors may weigh more heavily than others. If you commit a crime when you're 13, and it can truly be described as an act of juvenile delinquency, however serious, that's one thing. If you commit a violent crime as part of an escalating pattern, hypothetically on the day before your 18th birthday, that is something fundamentally different. There's no uniform approach or rule, or a set weight to be given to, for example, age. There's merely a factorial approach. That is the point that was specifically made in Unuane at paragraph 78. And the second consequence of the analysis being factorial, with varying weight to be given, is the very important principle set out by Lord Reid in Alley, page 564, at paragraph 35. If I could invite you just to go there and read that. My lord will remind me that you said within limits, which you did. But the principle is nevertheless important, and I've made the point about it being a fortiori in circumstances in which, although the Act I think had been passed at that stage, you weren't considering it, you were just considering the policy in the immigration rules. It's a point that applies with particular force when primary legislation has intervened, and that primary legislation is directly and intendedly targeted at the providing a framework of analysis for the courts.
Now, Sir James, I'm sorry to have to interrupt you, but we're going to have a short adjournment.
Of course.
We'll break for 5 minutes. We're ready now to resume. Sir James.
Oh, just before I come to my third point, my Miss Anderson informs me in response to some questions that my lord, the Lord Chief, was asking about the sentencing and the guilty plea, that the tariff we think is or was a third of the guilty plea, which doing the maths wouldn't quite take you down to the 3-year slot, which rather reinforces the point that I was making, that the sentence after, the sentence referring to the starting point in 5.5 years, might have brought in other factors, but a small point. The third submission on Maslow, then, if I may, is that Maslow did not and is not to be understood as having laid down some universal supervening rule that offending whilst a minor or spending a major part of childhood here automatically requires some different approach and additional or more powerful reasons for deporting. And I would add in brackets to that, regardless of the seriousness of the offending or the paucity of the private life in the host state on the actual facts. So in other words, it doesn't result in something under which the Article 8 factorial approach, long established in the case law, is displaced by some condition, precedent, subsequent, whatever you choose to call it, some new principled approach triggered only by those matters. And we note in relation to that a few sub-points, if I may. Firstly, that is not how Maslow was read or taken in Lord Reid's analysis of Maslow in Alley that we looked at earlier, where that was cast correctly, we submit, as a factor to be taken into account. correct to analyse it in that way, we respectfully submit. Because, as I think Lord Sales pointed out, para 72, first sentence of Maslow, don't need to go back to it, and also 75 itself, suggests that the court was not applying it separately, but as part of a well-established factorial approach in which all the criteria are weighed up together. My learned friend's only real answer to that was say, no, you can tell it's a test because lawfulness or legality is introduced for the first time in para 75. But that doesn't turn it into some sort of test supplanting the factorial approach. And in any event, we note, the lawfulness of their stay is something that could in any event have featured within the fourth factor that the court identified at paragraph 71. Leverkitch also provides no support for the sort of introduction, displacing introduction of this sort of test. Paragraph 45, again, I don't invite you to go back to it now, but paragraph 45 at 708 suggests the contrary, that it's part of a factorial approach, it's part of the factors, it isn't some kind of condition subsequent. And you get the same thought, as Lord Reid pointed out, from the concurring judgments at 710. Hormez likewise, at paragraph 52, 748, positively supports it being part of a balancing approach. So we respectfully submit that Lord Reid's description 26 of Ali is correct. But secondly, it would in any event be inimical to the long and well-established factorial approach, which allows everything to be weighed in accordance with the specific facts of the case and does not dictate outcomes. Thirdly, it might be thought that the introduction of that sort of test triggered in that way would be contrary to both logic and principle, because it would involve treating the mere fact, say, of juvenile offending, i.e. the fact that you happen to be 17 on the day, you treated that as fundamentally recasting the basic approach and test. It would require, therefore, for example, a rape aged 17 and 9/10 of an unintegrated foreign national to be treated as requiring strong reasons before you could deport because of the 10th, whereas the factorial approach would be the correct one to apply without that test or without that introduction, displacing introduction, if only the person was 18 and a day afterwards. Our respectful submission is that the true distinction drawn in Maslow, saying nothing terribly surprising about age being an important consideration, the true distinction drawn in Maslow is between offences that can be characterised as really mere juvenile delinquency of a genuinely integrated person who's resided here since early childhood, and serious offending resulting in significant custodial sentencing. And that can be seen, we respectfully submit, from the case law. Again, I don't invite you to turn them up now, but paragraph 73 of Azarkan and the Netherlands at 731, they took into account all the offending, declining to find that theft accompanied by an act of violence was mere juvenile delinquency, and having specific regard to the fact of the robbery when he was 18. Onur, O-N-U-R, analysed in Akpinar at paragraph 35, that's a paragraph 35 of Akpinar, the nature of the offence might just be worth turning up at Akpinar just to get the facts from there conveniently. So Akpinar starts at 482 and Onur is described at paragraph 35, page 500. And you'll see from that paragraph and that description, including the quote from the analysis of the European Court of Human Rights, that that he claimed that the offending occurred when he was 17 or 18. The court doesn't say, well, we better find out whether it was actually 17 or 18, because the whole game is going to be fundamentally different if the juvenile offending box is ticked. Instead, they looked at the offending in the round, and for obvious reasons, they attached particular importance to crimes which involved a serious invasion of the integrity of the person, the robbery with weapons. The next submission is that we do respectfully submit that the approach and analysis of the Court of Appeal in Appellant was correct for the reasons they gave, especially at paragraph 28, 495 and following. My learned friend sought to suggest this morning, no doubt for good forensic reason, that he agrees with large parts of the analysis in Appellant. But it is important to note that their analysis was not dependent, that's of Maslow 75, was not dependent on a distinction between a condition precedent and a condition subsequent. It was dependent on rejecting the base idea that paragraph 75 introduced some consistent objective hurdle that needed to be surmounted for all cases falling within the cohort. And the reason that they rejected it in that way is evident from the analysis that they undertook at 30 and following. So there was extensive citation of the past case laws indicating, that's in Maslow, there was extensive citation of the past case law of the European Court of Human Rights itself. They took that as indicating no intention to depart fundamentally from the factorial balancing approach by introducing some a priori rule or some condition subsequent rule. And they contrasted tellingly in point of principle for the purpose of testing whether or not some new and hard-edged test was being introduced by reference merely to the existence of, say, juvenile offending or having spent some time of your life in the jurisdiction. They rejected that those mere facts would trigger the introduction of the new of this new and hard-edged test wherever it may fit in the analysis, because it would lead to incoherence, as they pointed out at paragraph 32. And the reason it would lead to incoherence is because offending and the significance of age and how long you've been here are infinitely variable things on the facts. And so we do respectfully submit that their analysis was correct. And we note, if you go please to CI Nigeria, I took you to briefly before for one paragraph, can I invite you to go to page 663 in the bundle? And the paragraph I want is paragraph 111. At the bottom of that page, this is in the judgment of Lord Justice Leggett, with whom the senior president of tribunals and Lord Justice Hickenbottom agreed. But you'll see what is said in 111 about Maslow, and indeed about Appellant. Perhaps the final point in relation to this head is if there was to be a switch of the fundamental kind that my learned friend needs and seeks to introduce, it is very surprising, we respectfully submit, that that isn't something that was clearly analysed, set out and justified in the Strasbourg case law. At no point in anywhere in the Strasbourg case law do they say, well, now we're looking at things in a fundamentally different way. They simply refer to very serious reasons in those cases which attract that and which warrant it. But there isn't any suggestion that there's a, as it were, a trip switch that creates this hard-edged new test. The fourth general submission I make under the Maslow head is that in any event, all of the relevant circumstances, including the fact that this individual had been here since 9 years of age, and the fact that he offended whilst a minor, if only just, can be and were fully taken into account on the actual facts rather than on the basis of assumptions. And I've touched on that already in some detail. So just to summarize, the scheme under the primary legislation allows for that to occur, and moreover and importantly, to be ascribed appropriate weight depending upon the precise facts of the case. The state is entitled to create that framework with its weighting, both of the specific public interest in deporting foreign criminals and also within the structured analysis that the court is invited to undertake. That scheme calibrates the offending, in effect giving more serious offending more weight. And introducing that system is not merely within the margin, but has the benefit in an area of real public concern and controversy of introducing a greater degree of consistency and objectivity within the tribunal system, ensuring, as it were, that that analytical framework is followed, even though it has the flexibility that we've been discussing. And there was concern before the 2014 statute that despite Lord Reed's judgment in Ali, that degree of discipline was not being exercised by tribunals, which no doubt in part led to the introduction of the primary legislation. That was a feature and a concern that was noted by the Court of Appeal in NA at paragraph 40, 529. And under that analysis, age can be fully taken into account. It's acknowledged to be a factor of weight in both the European Court jurisprudence, Una, Maslow, to name but a couple, cited by Lord Reed in Ali at paragraph 26, recognised in the domestic cases below the level of this court. See, for example, NA at paragraph 34, page 528, recognising the significance of age in the analysis. And it can play into the framework in a variety of ways. AS is excluded from the automatic deportation regime, given that he offended whilst he was a minor. I took you earlier to 33.3 of the 2007 Act, you remember that, cited in NA at page 518. Age feeds into sentencing, again an issue we've discussed, and the upper tribunal considered age at the time of offending, again under very compelling circumstances. The statutory regime also requires one to take into account how long you were here. How long have you been here? I've been here since I was age 9, taken into account as an integral part of assessing whether or not you fall within exception 1. There are various other ways within the system of a broader kind in which age feeds into this whole process and system. For that purpose, can I simply refer you to our case at paragraphs 55 and 56. The fifth submission is that taking into account in that way can be done without distortion to the legislative framework and its inherent balancing. You only get into the scheme of 117C if you've committed serious offending. And if you are in there, as I indicated earlier, and it's within the margin of the state to design this, if you are within there, then the various factors that were of concern and have obviously been of concern to the European Court and the domestic courts related in particular to age can fully and properly be taken into account. The point about margin has an echo, because if my learned friend is right, that would be to destroy the margin. He seeks to inject into the scheme a hard-edged automatic rule, which in effect is designed to determine the outcome that is triggered by length of time here or offending as a juvenile. But that isn't consistent with the Strasbourg case law and its factorial approach, and it isn't consistent with the exercise within its margin by Parliament of the various weightings that are built into the scheme. And that is precisely illustrated by the fact that despite my learned friend's disavowal, because it was never raised before and has never yet been raised, of asserting incompatibility of the legislation itself, in the same breath this morning he said, but there's nevertheless a design flaw. And the design flaw principally appeared to be that very compelling circumstances, when you get to 6, if you get to 6, as it were, flips the burden. But we respectfully submit that that's entirely within the margin that Parliament can introduce. It's entirely within Parliament's proper function to determine those aspects of weighting, of course, bearing in mind the discussion I had earlier with Lord Reid about how it isn't, as it were, exclusive. The 6th submission is a factual one. There were plainly very serious reasons here in any event. A key offending was done when he was 17. He'd had all of the features already outlined. His age when he offended was relevant, but did not diminish the clear seriousness of that offending. Escalating, predatory, targeted robberies of the vulnerable at night, at knife point, coupled with a history of similar offending. And that was the conclusion in terms, brackets, in terms reflecting directly very serious reasons per Maslow, with very serious reasons normally at least overlapping to a very significant degree with very serious offending. That was the conclusion in terms that the upper tribunal reached in the paragraph that I took you to earlier. That's what I want to say about ground 1. So far as ground 2 is concerned, the very significant obstacles to to integration. This is at the earlier stage. This is point C in exception 1. And the submissions are short in relation to that. The upper tribunal, unlike the FTT, applied the right test as set out in the primary and as reflected in the immigration rules. Point 1. Point 2, it undertook precisely the broad Camara evaluation that was required through the case law. 3, none of the factors to which it had regard could possibly be said to be irrelevant or not proper factors to take into account. 4, there is no question but that those findings were findings that were open to them on the evidence. And as part of that, the ultimate conclusion and judgment about whether or not, taking all of those matters into account, they surmounted the statutory hurdle of very significant obstacles was a matter for them. And in any event, we note, they still went on to consider whether there were very compelling circumstances, him having fallen outside exception 1. There is nothing in the suggestion, if it is persisted in, that the old immigration rule with its reference to no ties is in some way to be equated with the new provisions and their reference to very significant obstacles. There's no permission to run that anyway, but it was clearly rejected and correctly rejected by the upper tribunal in their error decision. That is the one annexed. They aren't the same, as that ruling indicates. And indeed, as was conceded from the upper tribunal upwards. The argument, as you've seen from the upper tribunal judgments and the Court of Appeal judgment, was about materiality of the error. And that was correctly disposed of by the upper tribunal and the Court of Appeal, see Court of Appeal judgment in particular, paragraphs 52 to 55. That's all I wanted to say about ground 2. Can I just say something very brief? And then my learned friend will have the luxury of more than 1 minute of reply. But can I say something very brief about the so-called pleading points? As I hope members of the court are very well aware, I do not normally make a fuss about those sorts of issues. But I do submit in this case that it is important in the orderly, fair and proper determination of these cases that the procedures that are laid down are followed. The appellate jurisdictions, and a fortiori this court, are jurisdictions in which decisions below can be challenged on points of law. And in this court, points of law of real importance that should be determined by the court. But that requires points of law to be squarely and properly identified and presented. The levels of appellate jurisdiction, including in particular this one, are not a free-for-all for the introduction of new points not raised below and thus not ruled upon, with the result that this court is deprived of the careful consideration that would otherwise have been given to them. And the permission stage, which exists under your rules, flows from that and is equally important. It enables the court above, to use that phrase to cover both you and the Court of Appeal, to see the point or points of principle and to apply the permission test with the benefit of the court's ruling below. And this court has not been put and was not put on notice and was not troubled in the grounds on which permission was granted with a submission which, despite the denial of it, is central to the case as now presented, namely that the statute cannot survive Maslow. That is an argument of incompatibility, which has never been run in those terms and was never run in those terms in the upper tribunal or in the Court of Appeal. And of course, incompatibility is a precondition to either of the alternative parts of the remedial scheme in the Human Rights Act. All those years ago, Lord Wolfe in Poplar Housing saying you don't get to section 3 unless you demonstrate that on its natural reading, an interpretation of the statute it leads to incompatibility. And the box saying, are you going for incompatibility on page 8 in your bundle, was ticked no. And again, unusually, we have made a fuss, and we've done so in detail in the case, in the face of the appellant's case, which, with respect, appeared to regard things as open season. Recreated in the latest document, suggesting that the onus was in effect on us to show some sort of prejudice. Well, that isn't the test or the approach at all. I'm not going to go through the concerns point by point, but that is not, I submit, a good, fair or permissible way to conduct proceedings at any appellate level, let alone in the Supreme Court. That's especially important, it might be thought, if what you're truly trying to put in issue is primary legislation, and you're asking the court to take steps of great potential breadth and effect. So I do maintain our position in that respect. And I would add, if I can finish on this point, I would add that it is also unfortunate that having raised all of those points carefully and in detail and advisedly, and I would add unusually, in our case on the 31st of January, it took until yesterday, 2 days before the hearing and a full month after receipt of our case, for a 7-page response, calling them rather dismissively pleading points, to be put in. I don't accept that they provide any answers to the point that we've made. But that lateness of even that document is not excused by the implication in paragraph 1 of the document that they'd only just heard from me that we were maintaining that position. Mr. Hussain sent me an email when I got out of court after court on Monday this week, and I told him the next morning at 9:21 that I very much doubted we would be retreating from any position advisedly taken in our case, and that was confirmed on Wednesday. There has never been any proper basis for any assumption that the points we made in our case would be abandoned or were not seriously being made, which makes it all the more unfortunate that that response was put in then, coupled with yet more documentation sent to us 10 minutes before the hearing started and the cameras rolled. I'm sorry that we've ended on that note, but it is important, I respectfully submit, because it makes life almost impossible, both for the court and for the advocates trying to present issues fairly before my lords, for that to be the sort of conduct of litigation before this court. In the end, however, we respectfully submit that this case is an appeal against a Court of Appeal decision. And that Court of Appeal decision was unimpeachable. My lords, those are my submissions.
Thank you very much, Sir James. Well, Mr. Hussain, you have longer than you might have anticipated.
My lord, yes. Can I just go through the points then? The fundamental point that Sir James makes is that Maslov does not establish a universal supervening rule requiring some approach, some different approach, or a more powerful reason for proceeding with deportation. And he makes a number of points in support of that. The first thing he says is that, my lord, you didn't recognize it as having that effect in Ali. That is an unfortunate submission, because in Ali, you were not confronted with a Para 75 case. As I've tried to say, I'm sure Mr. Eady has the point, and there is an element of too much protestation with regards to most of the things he says, with great respect to him. The points that I have made on Maslov are that A, Para 71 is weight neutral. It's the bull teeth criteria picked out for children or people, or Maslov, people who've spent their childhood in the host country. So they are weight neutral. The second principle, paragraph 72 to 74, that is also, it's not quite weight neutral. It says particular weight is to be attached to people in those situations, but it's paragraph 75, which critically isn't weight neutral for the reasons your lordship have. And you were not concerned with that, my lord, in Ali. You were concerned essentially with bull teeth and Maslov applying bull teeth, i.e. Maslov 71. We don't say that Maslov 75 supplants. The fact that legality could have been in the fourth factor in paragraph 71 is neither here nor there. It wasn't there. It's not in the fourth factor. It's not in the second factor. It's something that's added as the court proceeds through the repercussions of the fact that you've got a juvenile offender as it proceeds along the spectrum of how long he or she's been here, as it proceeds to see whether or not the stay was lawful. Levakovic, para 54, sorry, para 45, the critical word is however. Weight not prescribed, however, it says, para 75 is different. Tormes, Malone French says that just supports him in circumstances where they make it very clear that there are different frameworks in play. My submissions are not inimical to a factorial approach. Absolutely not. They don't dictate the outcome. Sir James said that twice. I've never counted for it. Straw man, the consequentialist argument that you have somebody who commits rape aged almost 18, well, there would be very serious reasons to deport somebody like that. Erner doesn't apply Maslov. It's one of the early cases which doesn't apply Maslov, so you don't get anything from that. Akpinar, Sir James supports Akpinar. He says the point about that was that it rejected at base the idea of a consistent objective hurdle. Absolutely, that's the problem with it. That's the second element of Akpinar. The first element is the rejection of the condition precedent idea. The second element is the rejection of any objective threshold idea. And that is the problem with Akpinar. And the other Court of Appeal cases make that clear. MW, DRC, Para 50 of Akpinar, and the Angolan case, Lord Justice Dyson. Lord Justice Leggett, as he then was in CI Nigeria, the passage Sir James referred you to, he is there, with respect to him, contrasting the fair balance on the one hand with the condition precedent idea. It's not something for which I contend. That's not just a forensic tactic. It doesn't make any sense. It doesn't make any sense. In fact, Sir James needs that because he needs to say, as he did in his baked-in submission, that it's the offending that provides a serious reason, which absolutely, I'll come on to the regime in a minute. And it's not surprising that it's not clearly stated we're departing from our previous case law, because the court wasn't departing from it, it was building on it, and it's precisely the kind of incremental development that you get in Strasbourg over time, just as you have in many systems, our system included. As far as the regime is concerned, my lords, the problem is this. Imagine a case involving a healthy young person who commits non-violent offences as a minor, has strong ties here, weak ties with the destination country, but can't get to very serious obstacles. Through the lens of Maslow's very serious reasons, that he would be likely to succeed. Through the lens of the very compelling circumstances over and above safety net, he would be likely to fail. Sir James cannot get away from that. And why is that? And it's because the statute simply isn't tailored to meeting the Maslow settled migrant. And the idea, that has a consequence. The first consequence it has, that there's no considered view to which the court should defer. And secondly,
so sorry, Mr. Hussain, can I just pick you up on the point that you've made, that through the lens of very compelling circumstance, as your theoretical person would be likely to fail? Because I thought the point of the MF case on the old rules and NA Pakistan on the new, as reflected in what was said in the Udunani analysis of the domestic case law, was that under the rubric of very compelling circumstances, all the balance of Article 8 factors would be brought into account.
All of those cases, my lord, sorry, none of those cases concern Maslow 75 people, none of them. And therefore, you're dealing with weight, essentially with weight neutral criteria, weight neutral factors. That leaves room for the national authorities to determine issues of weight. Maslow 75 is different. It is not weight neutral. It is weight specific. That is the difference. I tried to make that clear in my opening submissions. MF is an adult. Ali was an adult. Unane is an adult. They're not Maslow 75 applicants. So going back to the regime, incompatibility, we don't say it's incompatible because the purpose of it is to secure Article 8 compliance in every case, and you can do it easily under Section 3. It's really disappointing to have these pleading points run again. I'll give you a reference to how it was raised in the grounds of appeal. Page 23 EF, paragraph 45. Please don't go to it. I don't have time. It's my fault, but if you would give me that indulgence. The result of the lack of tailoring is that there is no deference. If there is deference, if there is a considered view, then I'm afraid the margin has been exceeded. There is a limit to it. It's been exceeded. Why has it been exceeded? Because very compelling circumstances, that's the basket, that's Sir James's sort of route out of the exclusion. Influence, don't exclude. His route out into influence is the safety net, very compelling circumstances. As my Lord the President said, that points in one direction, very serious reasons points in the other. So those are the submissions we make on the regime. As far as the facts are concerned, Sir spends a lot of time, understandably, on the facts. Repetitive, not one-off, escalating 3 or 4 year period, he says. And so there were very serious reasons. I'd invite you to the note that we provided on a review of the Strasbourg case law. I'm sorry if that caused him difficulty. I'm sure it did, given the point I made about the grossly misleading, which he hasn't controverted, the grossly misleading summary of the Strasbourg cases in his printed case at footnote 5. Those show that there is absolutely nothing in the idea that you could say inevitably this case would fail. Consider bull teeth itself, a case with quote unquote striking facts. Consider the Mustakim case, 147 offences, 26 charged, 22 convicted. There is no double counting here. Bad point as a matter of precedent. Austria runs the point, paragraph 58 in Maslov. They ignore it. Why is that? Because just as aggravating factors in criminality count in deportation, so do mitigating ones, so does age. The tribunal's errors, the idea that you can build back in issues under the exclusion criteria that you've lost on, that seems quite important for Sir James. The tribunal don't do it. If you look at the section in their judgment, and it's just above 46, I think it's 46, where they begin to deal with very compelling circumstances, they do not feed back in to the analysis of very compelling circumstances, the lawful residence for the majority of childhood and youth. And indeed, they discount the weight. They discount the weight to be given to age because they think it's been taken into account already. That was the sentence at the end of paragraph 47, which I think Lord Sales was referring to in an exchange with me. I haven't quite got the point. I'm sorry if I missed it. But the point is very clear. They think without any reason whatsoever, no explained reason today, how it is possible to say that the regime, they're the rules, the act builds in age. It's age neutral. Sorry, my lord.
I was just wondering, Mr. Hussain, whereabouts in the application for permission to appeal, was there any suggestion that Section 3 of the Human Rights Act should be deployed in order to properly construe Section 117C?
It wasn't clear. I completely accept that. But can I read you the sentence that I relied upon, please? It's paragraph 45, EF 23. A decision under Article 8 in a particular case which fails to reflect this, that's Maslov, or immigration rules or statutory provisions are not interpreted with this in mind, will for that reason fail to comply with Article 8 ECHR. I accept entirely that that my predecessor did not raise in terms Section 3. I accept entirely it would have been better for me. I take full responsibility for it. to have raised the issue before. And I apologise for not doing so. But this is an important point. Mr. Eady has given you very full submissions on it. And the problem is that the Court of Appeal case law, which is obviously binding on the Civil Division, means that the approach that we have hitherto had, it will dominate, will continue to dominate and control. It's not going to be straightforward at all to see how your lordships, if you would like to entertain the point, would be able to. I mean, I'm not sure I can say any more than that. So on the tribunal's errors, the point I was, sorry.
I'm afraid yesterday I had to pull the plug on council because they showed no sign of finishing long when 4 o'clock was long past. You have to.
I'm going to. I'm going to say one more thing, which is on issue 2. Again, very clear. We raised the issue of no error in the FTT. We raised it, or my predecessor raised it. EF page 27, paragraph 64, Roman 2. Again, with great respect, unusual, but too much protestation. Thank you.
Thank you very much. Well, we're grateful to both counsel for, and indeed all counsel involved in the case, for their assistance. We'll now take time to consider our decision, and the court will adjourn.